I've got a great question for you. Is it good practice at the beginning of a trial during opening remarks to tell the jury how much money we're asking for? Would you like to learn the answer? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. The answer is no, it's not good practice, and here's why. If we were to tell the jury at the very beginning of the trial how much money we think you're entitled to, you know what's going to happen? They're going to get a knee-jerk reaction which says to them, hey, I don't understand. Why is he asking for $5 million and I know nothing about this case? I don't know what the wrongdoing was. I don't know how the wrongdoing caused injury. I don't even know what the injuries are. I don't know what harm and suffering this person experienced. So how could they possibly ask me to award $5 million to somebody at the very beginning of the case when I have no clue what's really going on? And that's one of the key reasons why you don't want to tell the jury at the very beginning how much money you're asking for. Now, there are some people who turn it around and say, listen, if we tell the jury a number at the very beginning of the case, that number is going to stick in the back of their mind. That is true, but the problem is they have nothing to compare it to. They don't understand what the true value is or how to measure the value of your injuries at that point. And so there's no feasible way for the jury, for each of the individual jurors, to recognize whether or not the number that you've just thrown out is enough to compensate you for the injuries and the harms and losses you've experienced. That's why you'll never see an experienced trial attorney tell the jury during opening remarks how much money it is that they're asking for. That's only going to come at the very end of the case, during closing arguments. Now, after the jury has heard all the testimony, they've heard from the doctors, they've heard from you, they've heard from all the witnesses, and now they have a clear sense of what the wrongdoing was and what injury you suffered as a result of that wrongdoing. Then they'll be in a much better position in order to determine whether or not the injuries that you have suffered are clearly worthy of the compensation you're asking for. So why do I share this great information with you? I share it with you to give you an insight and an understanding in just one trial strategy that occurs when you bring a case involving an accident matter, or a medical malpractice matter, or even a wrongful death matter here in the state of New York. You know, I realize you're probably watching this because you have questions or concerns about your own particular matter. Well, if your matter happened here in New York and you do have legal questions, one of the things I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, I do this every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.